The political controversy over SNC-Lavalin is bleeding over into the court case against the construction firm. The company is facing serious charges, but it now says its case should get another look in the courts because of what's come to light in the ongoing political scandal. Here's a recap of those charges against SNC-Lavalin. It's alleged that between 2001 and 2011, SNC bribed public officials in Libya with millions of dollars in order to secure government contracts there. The RCMP laid charges in 2015. Today, SNC argues those responsible are no longer working for the company, and it has beefed up its ethics and compliance rules. That's why SNC has been pushing for a DPA, a deferred prosecution agreement, instead. This option became available back in September. It's kind of like a plea bargain. Charges are dropped if the accused, say, admits to wrongdoing or pays a big fine or cooperates with authorities. In this new appeal filed by SNC-Lavalin, the company says, quote, "New and deeply troubling facts have come to light about the rejection of a remediation agreement." That's the sort of plea deal a company sought to avoid criminal conviction and avoid being banned from bidding on federal infrastructure projects as a result. The company now says former Attorney General Jody Wilson-Raybould's testimony at the Justice Committee shows that decision needs to be revisited.
My view had also formed at this point. Through the work of my department, my minister's office, and work I conducted on my own, that is what was inappropriate, that it was inappropriate for me to intervene in the decision of the Director of Public Prosecutions in this case and to pursue a deferred prosecution agreement.
In court documents, the company says it submitted new information that wasn't passed on to Wilson-Raybould, saying, in short, having initially consulted the former Attorney General, the DPP chose not to do so when additional information was provided by the applicants. This failure lies at the heart of the DPP's decision-making process, the document goes on to say in this matter, and constitutes a clear abuse of process. So, does SNC-Lavalin have a point? Does testimony from Jody Wilson-Raybould change things for the firm? Kenneth Jewell is a lawyer at Gardner-Roberts and a law professor at the University of Toronto. He joins us from Toronto now. Hi, Professor Jewell. Great to see you again.
Great to see you.
Thanks for your time. So help us understand here, what is the new information that SNC-Lavalin is saying they presented to the Director of Public Prosecutions?
Okay, so we're early on in the day in the sense that this is just an amended appeal. We haven't heard what the government will say about this, but let me follow the chronology, and I think it'll help you and help your viewers understand this. So we start on September the 4th, and if we go back to September the 4th, on that day, September the 4th, 2018, on that day, SNC-Lavalin is told that they are not going to be given an invitation to have a DPA. On that day, we know now that the Department of Public Prosecutors issued what's called a Section 13 notice, which set out the reasons for that. SNC-Lavalin was not given those reasons, but they were given to the Attorney General. Now, September 5th, they have a discussion, the prosecutors have an oral discussion with SNC-Lavalin, and in that oral discussion, they say to them, there are 3 reasons that we're going to tell you about that led to you not getting the DPA. Number 1, the seriousness of the charge. Number 2, the seriousness of the level or the level of senior officer involved. And number 3, and this is the one that I think is important, they say you're not going to get a DPA because you failed to self-report. And I just want to talk about that.
What does that mean?
A little bit, and then we'll go on back to the chronology. So it's what I call the concept of coming in from the cold. The idea of the DPA is it invites companies to come in from the cold when the government doesn't know about the misconduct, to self-report their misconduct. And the DPA is a type of carrot that says if you do that, you'll be rewarded by not getting a conviction and not being debarred. You'll have to pay a penalty and all of those other things. But the incentive is to self-report and tell the government about things that they don't know about. Now, here's where it gets interesting. This is where SNC, I think, has an interesting point. At the time that SNC-Lavalin discovered these bad events, we're going back a number of years, in and around 2012 to 2015. At that time, there was no deferred prosecution agreement available. And they could say that they had no safe harbor to come into. And why is that important? Well, had they self-reported in 2012, they would have been convicted and they would have been debarred for a period of 10 years, perhaps 5 if they cooperated. So they have a case to say that it's not fair to them to blame them for not self-reporting when there was no deferred prosecution agreement available at that time.
Would that be the new information, for example, that they would have brought to the DPP, the Director of Public Prosecution?
Yes, so let's talk about that. So then what happens is they then write a letter on September the 7th to the Department of Public Prosecutors with a detailed letter. We don't know what the letter, we haven't seen the letter, but they say they put a lot of detail in that letter to the DPP about this point, saying that making points about self-reporting. So that's an important point. Now, what's the next thing that happens? I think the next critical event in time is probably September the 16th. That's when Minister Jody Wilson-Raybould makes the decision that she will not intervene. The essence of what this appeal is saying is that the DPP did not pass on the information that they had recently acquired to the minister. So therefore, when she made that decision on the 16th, she wasn't aware of this new information. And they also say that they followed it up. The DPP had asked for a follow-up, and they followed it up with a letter on September the 17th. So they're following up, giving information on September the 17th when the Attorney General has made up her mind, in effect, so they say, on September 16th. So this is pretty interesting.
Is the DPP required to present any new information to the Attorney General, to update, in essence, the Section 13 notice, which is the notice that would have described the reasons that the Director of Public Prosecution decided against pursuing a remediation agreement?
Well, I think, when you use the word required, that's a strong word because it suggests a statutory requirement.
There isn't one?
There's certainly nothing in the Remediation Act that even talks about this. And in the DPP Act, it refers to the power to obviously tell the Attorney General. But I think it could be argued that having made the decision to issue a Section 13 notice in the first place, in my view, having made that decision, it would be appropriate to update it with new information.
And is the new information that we were just talking about, how persuasive do you think it is?
Well, I mean, there's a lot of it, but I think the issue of self-reporting has some merit to it, because if it was decided to not give SNC-Lavalin a DPA, and as you recall, there's a lot of factors here, there's 9 factors, but if the decision was made to not give them a DPA on the assumption that they had failed somehow to do something they should have, which was self-report, if it turns out that, if you agree with me, that we should have some sympathy for them, because at the time there was no DPA available, there was no safe harbor, and they had a valid excuse under those circumstances. Now, it's obvious a company should self-report. I mean, obviously they are
whether
listed,
there's a safety net or not.
Right. I mean, because they're a listed stock exchange. They're on the listed stock exchange. It's a material change in circumstances. They probably should have reported. I think arguably they should have, and their shareholders said that, and they settled a lawsuit with respect to that. But I think, so I'm not saying it's an excuse simply not to self-report, but it is a factor, I think, as to why they may not have self-reported, that they didn't have this avenue available to them.
I just have a few seconds left, but what legally happens next?
Well, legally next, of course, the government will put its response, and this will be fought out in the Federal Court of Appeal.
Okay, we'll watch for it. Thank you very much, Professor
Right.
Jewell. Appreciate
Thank
it
you.
as always. Meanwhile, Jody Wilson-Raybould is denying that she tried to meddle in the SNC-Lavalin file after she was shuffled out of the Attorney General's job. That's after sources told CBC News Ms. Wilson-Raybould wanted an assurance that the new Attorney General would not overturn her decision in the case. David Cochran joins me now with more. Hey, David, nice to see you. So first of all, let's start with the denial from Jody Wilson-Raybould today.
So what we reported on Wednesday night is that during the negotiations and conversations Jody Wilson-Raybould had with the Prime Minister, Cabinet Ministers, and caucus members about trying to resolve of this Liberal civil war, that 5 conditions emerged that have amounted to assurances, an apology, and some terminations. The one that she is contesting on the record, publicly denying, is that she sought assurances that David Lametti, her successor as the Justice Minister and Attorney General, would not be directed and would not direct the Director of Public Prosecutions to do a deal with SNC-Lavalin to give them a deferred prosecution agreement. She initially told us no comment when we asked her about this story, and then she issued an explicit denial. This is what she said to our colleagues on Vancouver CBC Radio.
I have to say unequivocally that I would never interfere with the independence of the Attorney General.
So you did not seek an assurance that your replacement, David Lametti, would not overrule the Director of Public Prosecutions and direct her to give SNC-Lavalin a deferred prosecution agreement?
I would absolutely never do that.
So Vashti, as I said, we contacted Jody Wilson-Raybould before we published this initial story. We told her what the 5 conditions we had heard of through our sources and what we were going to report. We explicitly spelled them out to her. She gave us a no comment. Didn't issue her denial until 24 hours later, first to CTV, which also reported on these after our initial story, and denied this, even though she had told the Justice Committee that she would resign from Cabinet as Minister of Veterans Affairs had anyone taken steps to give a DPA to SNC.
She said if it was gazetted, right?
Like exactly. So we went back to our sources after her denial and we rechecked our information, and they are insistent that this was part of the private conversations that Jody Wilson-Raybould had with Liberals from the Prime Minister on down. It was first raised directly with the Prime Minister in their meetings in Vancouver in the days before she resigned from Cabinet, as they discussed a path forward for her to stay in Cabinet. Throughout the conversations that went on for weeks, the list of things she wanted to see to sort of broker this peace, it shifted and changed. And as things got into this final stage, when the conversation has shifted from obviously, will you stay in Cabinet because she had quit, to will we even be able to keep you in caucus and in the Liberal Party, this was not part of the conversations. So something put on the table early in the conversations, gone by the very end of it. My sense is that she clearly got a sense of how it would look, that she was seeking to direct her successor as the Attorney General, and the impropriety of that because it was against the principles that she wanted in that job.
What about the other conditions that you mentioned?
Well, she was asked about this too, because we also reported that she wanted some firings right at the top of government, and that in particular she wanted the Prime Minister to fire his Principal Secretary, Gerald Butts, fire the Clerk of the Privy Council, Michael Wernick, and one of the PMO's senior advisors, Mathieu Bouchard. She was asked about that today on Vancouver Radio. This is what she had to say.
Did you ask that Gerald Butts, Michael Wernick, and Mathieu Bouchard be fired?
There was a number of conversations that was had, but those conversations came after January the 14th, after I was shuffled out as the Attorney General, and those conversations are still covered by confidence, and I respect the confidences that I had.
So interestingly there, she says the Cabinet confidence still applies. This time period was not part of the waiver covered by the order in Council, but so too were conversations about DPAs and an apology. She has said publicly she wanted an apology and publicly denied a DPA. No comment at all on what's happening in terms of her request for terminations.
Okay, thank you very much. David, the CBC's David Cochran.